call. All right. Gareth Hughes.
Kia ora, Mr Speaker. I'm happy to take the call on the first reading of the Copyright Infringing File Sharing Amendment Bill. File sharing is a fact of modern life. ISPs say sometimes at night 90% of the internet traffic is in fact illegal file sharing. The internet has built connections, increased global communications as significant, if not more, than the telegraph. It's contributed to more collaborative ways of working. The internet has revolutionised business and the global economy. The internet has unleashed fantastic creativity from the arts to academia to business. However, making a business out of creativity is in many cases not a viable proposition because of illegal file sharing. The Green Party supports this bill at first reading because whilst it might not solve the problem, it will play part of the solution and sends a good message that what is happening is illegal and damaging New Zealand creatives and internet entrepreneurs. This bill is an affirmation in New Zealand creativity. At the moment, essentially the only sector making money out of Kiwi musicians and Kiwi filmmakers' hard work is the ISPs. If we want a growing, viable and exciting Kiwi music and movie industry, we have to protect their rights to make a living off their work. A whole generation has grown up not paying for film or music. This isn't sustainable. The internet has created a new digital economy. This bill will help entrepreneurs to maximise the internet as a means of making their living. Other countries with file sharing protection like Sweden that have implemented something similar along these lines has seen legal music services increase dramatically. Those companies that weren't viable now are. New technologies like the internet mean we need laws that allow new business models to develop and flourish. This bill is a first step in that direction and it won't be the last before this House. This bill amends the Copyright Act from 1994 to provide new enforcement measures against the unauthorised sharing of copyright material via the internet. It repeals Section 92A of the Act, which was not brought into force, that would have required ISPs to adopt a policy providing for the termination of repeat infringers' internet account. In summary, it cleans up the mess made by the previous government regarding Section 92A. This bill goes incredibly far towards the demands set by the Creative Freedom Foundation and others in response to the draconian Section 92A put forward during last term. It repeals the existing Section 92A and replaces it with a notice-on-notice system which copyright holders can then use to go to a tribunal and ask for penalties for repeated copyright infringement. The Green Party was the only party to oppose Section 92A at every stage in the House, offering genuine amendments to fix it. This bill removes the onerous definition of ISPs and the awkward way they were being made into police, jury, judge and executioner, all at their own cost. On balance, our concerns are being conscientiously addressed and the Minister Simon Power is to be congratulated. We still have some niggles with some of the definitions and with the service cut-off provision, which many think are pointless. There are also issues about how open wireless points can be handled and the kind and level of fines to be issued within the statutory limit. We were also interested in looking at the termination issue, because even if an infringer has their connection terminated, they can still switch providers. And I believe the question can be rightfully asked, such as asked by Bronwyn Holloway Smith of the Creative Freedom in New Zealand, is the internet a core vital public service? You wouldn't terminate someone's right to post a letter. We look forward to looking at this bill in detail in the Select Committee and the Greens will be supporting this. This bill is an essential part of protecting Kiwi creators and strikes a sensible balance between ISPs, copyright holders and file sharers. We still have some way to go to change the culture of file sharing in New Zealand. Movie file sharing amongst young New Zealanders commissioned by the New Zealand Federation Against Copyright Theft found that a notice from the ISP would be enough to stop 71% of young people further accessing illegal copies of movies. Along with the notices and potential financial penalties outlined in this bill, education is important. My generation has grown up with the culture of file sharing. I probably watched illegally downloaded material and shared files which breach copyright. In many cases, people simply aren't aware what they're doing is wrong, or in fact the material they are accessing has been provided through illegal means. Unlike the previous amendment, this bill has widespread public support from the Creative Freedom Foundation, Internet New Zealand, Library and Information Association of New Zealand and APRA, the Australasian Performing Rights Association. APRA speaks for our Kiwi creatives. They say it's not their intention to cut people off from the internet, rather taking continue to allow creatives to make a living from their skills, knowledge and energy. Sure, musicians can make money from performing live on the street, as they always have and always will, but they cannot be reduced to this as the only source of income for some 19th century street musicians. Screen Directors Guild Executive Director Anna Carhill has said, New Zealand artists and audiences stand to lose unless the government strengthens the proposal to build a framework for stopping online copyright infringement. Digital copyright protection is crucial for new digital business models to be successful. The bottom line is the creator should be paid if they want, but internet users also need protection and balance. The fact is, file sharing and downloading copyright files is now a social norm. Previously, the Copyright Enforcement Agency required a court order to obtain the identity of the infringer from that infringer's ISP. The costs often outweighed the possible damage or didn't justify the effort. We've missed a great opportunity over the years, over the course of the internet's existence in New Zealand, to protect digital copyright and establish different social norms in this country. This has to be taken into account. It can't be assumed all infringers are brazen criminals trying to steal creatives' work for financial gain off your brother, your cousin or your boss. There are genuine repeat offenders who are doing significant damage to our creators and in many cases do arguably deserve the $15,000 potential fine. These people know exactly what they're doing, aware of the illegality of it, and motivated by currently being able to get away with it. We do need some clarity around this fine schedule though, because it is unclear what level the fines will be. For example, the $15,000 maximum fine is modelled on the same limit from the Disputes Tribunal, and at present we all know that the amount will be based on damage to the copyright owner. But in practice, how much will a movie or an album be fined for? The public must be given some real figures. If the purpose is parading a maximum $15,000 fine to scare the public into compliance, then the education incentive of this bill will be lost. In summary, the Green Party looks forward to submissions in the Select Committee, and we will be voting for this bill at its first reading. Kia ora.
Right.